Impact of influence.
Covering true crime throughout the Southeast.
Hello, friend. So grateful you're spending time with us again. I am Matt Harris. Seton Tucker is here, and we're going to talk Murdoch again. But don't worry, if you're interested in the Jimmy Robertson case we've been covering, there's more episodes to come of that. Another true crime from throughout the Southeast, but Murdoch keeps rolling around, or at least Murdoch adjacent at times. And Seton, where can they find us?
You can find us on Facebook at Impact of Influence.
And YouTube channel is up and going. Best way to go through that, find that, is to go to the Facebook page. All right, so we bring in our guest. He's been on the podcast before a few times, and during the Alec Murdaugh trial, you may have seen his silver locks in the gallery every day, and on Court TV with me, and many other times, many other shows. Joe McCullough is a seasoned litigator, former prosecutor, over 40 years of experience, founder and past president of the South Carolina Association of Criminal Defense Lawyers, very familiar with South Carolina law, and most of the players involved in the Murdoch trial, as a matter of fact. Like most, if not all, of the attorneys involved in the trial graduated from the University School of Law of University of South Carolina. So he's friends with these guys, and he knows Alec Murdaugh. He even sued Alec Murdaugh at one time. And here he is. Hey, Joe, welcome.
Hi, guys. Glad to be back.
You are back. So just for a second here, people knew that you had, it was public that you had a little bit of a health scare prior to the jury tampering hearing. How are things? If you want to share.
Oh, hell, if that was a scare, I don't know what a real serious problem would be. I had a big old fatty of a heart attack in January that got me a stent and then had open heart surgery in March. So I'm now back, and it affected my energy level a little bit, but I'm still as cynical as always.
Well, you felt well enough to do a big trip. Did you? I saw that. I think you were in Europe. I mean, it looked like a pretty amazing trip.
Yeah, my wife had planned a marvelous trip to Greece, and so we blew out of here, and I kind of hobbled around. That was a couple of months ago. So anyway, I'm back at the desk, answering the phone and working about 7 hours or 8 hours a day, which is, what I do.
Well, we're all extremely happy with you came out of there with the same old attitude we expect from Joe.
And you attended the hearing that was held in Columbia in front of former Chief Justice Toll, just very shortly after. So you are dedicated.
Yes.
Yeah, I'm a tough guy. I got out of the hospital bed on Thursday and was there Monday, and got chewed out by Judge Toll, who's an old friend, and she took me back in the hallway and gave me down in the country. But I said, Judge, duty calls. So anyway, our crime cup continues to runneth over with all things Murdoch, the case that keeps on giving.
Yeah.
That we don't have a new body count, but certainly the issues keep on coming.
Yeah, so you represented some of the jurors in the Murdoch trial. We're going to get to something specifically about that in a second. But none of the jurors were in any kind of legal trouble as far as we know, but they came to you for representation. Can you explain way back why that occurred that way?
Yeah, I don't think that's a matter of confidence, because I was contacted first by juror number 785, who was fondly referred to as the Egg Lady, after her removal from the jury, with the judge saying, "I'm not finding you've done anything wrong, I'm just going to remove you." And her problem was that the press was beating down her door. Now, subsequent to that, of course, the jury verdict occurred, and the second juror, number 630, who later testified in the Justice Toll hearing, she likewise learned that I was providing assistance to 785. It's terrible to refer to people by numbers, but to protect their privacy, we do that. And they both had the same concern. They didn't want publicity, unlike some members of the jury who actually flew to New York with the clerk of court on NBC's dime they didn't really want publicity then. They wanted to be left alone. They had been through, both had been through 6 weeks of the trial, and were, just wanted privacy. So I then reached out to media. That's why this is not a matter of confidence. I reached out to media at their request and said, leave them the hell alone, and was successful in that. Now, that was then, and this is now.
Right.
Juror 7085 has written a book called, I think the title includes Enough is Enough, which kind of says it all. But I think it is fair to say on their behalf, there being the jurors 785 and 630, that they have the concern, based on what they know, and they have each given either affidavits to the defense or have appeared at the hearing more recently before Justice Toll, and said they were pressured by the clerk of court in a way that impinged, interfered with their objectivity, their neutrality. And of course, our rules say that no one, including the judge, is to ever speak with the jurors privately, invade the province of their privacy in their deliberations and considerations of evidence, and certainly in reaching their objective decision. So they now are prepared to be a little more public, with the exception of their names being featured, but more public in expressing themselves about the fact they don't believe that even Alec Murdoch, maybe in many people's opinion, in the lowest form of life on earth, and a murderer, they believe that even he is entitled to a fair trial, and they do not believe he got one.
Okay.
So that's the end of my soliloquy, Seton.
No, I want to ask you. So did either one of your clients have concerns? Because, a lot of people, the media was tracking them down, and it did seem like there was a lot of online stuff. Maybe did they have concerns that their identities were already revealed?
Well, I have said to both of them, I think that your identities are the worst kept secret on the planet. But the fact is that the judge issued an order at the beginning of the trial, consistent with our usual practice in high profile cases and cases that involve the potential for threats of harm or actual harm to jurors. And that typically comes up in, cases involving the mob or gangs. In those cases, we have judges simply order the gallery, order the media, not to invade the privacy of jurors by giving information that is personal, that would create a situation of identification, personally identifiable information. And in this Murdoch case, even after that order, a member of the, you could call it press or journalism, put online information that was rather specific about the jurors' employment, places of employment, which could have been used by anyone to identify them. And so that resulted in some sanction, I understand, about that particular media person. But that's been the order of the day in this case, and that's why we use numbers and so forth, even through today.
Okay, so let's go to today and yesterday, whenever it was filed. The motion you have filed on the behalf of one of the jurors is to release some of the documents that have been sealed. Explain why she wants it to be open.
Well, Matt, I think for your listeners to understand the reason for that, when issues were raised apparently by the clerk of court at the end of the trial, hours away from the jury going to the jury room to begin deliberations, the clerk of court presented information to the judge that today is truly suspect information. And the judge began what we call backstage or in-camera interviews with all the lawyers present. And that led to juror number 785 being excused. But all of those discussions, interviews about 785 and whether she should continue to be on the jury occurred, and the proceedings, including emails and some other information, all of that was sealed by the court. and it's what we understand and what we say in this motion on information and belief, was to protect the confidentiality of the juror. Now, last year, I had the consent and agreement of the defense and the prosecution to that resulted in Judge Newman issuing an order that allowed me and my client 785 to have access, but did not allow me to disseminate that information beyond our need to know. Upon that review, I concluded that that was information that I'd rather not be hamstrung about talking, referring to, talking about. And frankly, I believe the public should know about every aspect of the Murdoch trial and about the reason 785 was excused. So we've refiled a motion, or filed a new motion, asking that that a judge, it will not be Judge Newman since he's retired, and we hope within the next 2 weeks to be arguing in a courtroom that that information should be fully unsealed for public consumption.
Now, we did receive a response from the AG. They released a statement, and they say that at this time they don't think it should be unsealed because of the ongoing matters. What's your opinion on that?
Well, my opinion is that's an excuse, and not a very good one. The public has a right to understand the judicial processes, especially when they're of this level of interest. But I'm not moving to unseal for mere prurient interest. I'm not moving to unseal the record to sell books, since I'm the only person in the world that ain't writing a book about this case.
There are a lot.
I'm unsealing this record, or moving to unseal this record, really for two reasons. One, I don't want to have the problem of somehow saying something that violates the judge's order. I'd rather be, be relieved of that concern. But also, I think the public has a legitimate right to see the process, to see how the sausage is made. Sometimes it's not pretty. And in this instance, based on what I know, it's a process that should be, it will certainly be the object of scrutiny in the appeals filed by the defense. And I think it's a matter of public consumption, or should be. And I believe that the position that somehow the keeping this information sealed up is important to the state's ability to prosecute their two appeals, that's not a good reason to keep it sealed, especially in light of the fact of the rationale for the sealing of the records. I represent the lady who wants the records unsealed for public consumption, who the judge sealed the records for. So if we're withdrawing any concerns, if we were withdrawing concerns, I don't think there's any reason left to keep the records sealed.
So 785 is the one who got kicked off, and she is the one who wants it unsealed. And originally said the state said they wanted it sealed to protect her, but now she's written a book and she's going to do an interview on television or on this podcast, hopefully. And so her anonymity doesn't need protected anymore. So that theory's out the window. But I also noticed,
and part of it may be that she really felt like her identity was already out there.
Right.
It didn't matter.
But on the motion, you still refer to her as a number.
Yep.
So explain that to me.
Well, I mean, I think that as we've already said, Matt and Seton, the fact of who the egg lady is by name is a poorly kept secret at best.
Right.
But I think it's just her desire. Actually, it may not be her desire any longer. That her name is not used in conjunction with this story. I believe her book will have her name on it. So at that point, the cat is fully out of the bag, if not on fire.
She might prefer to go by her real name instead of Egg Juror. She's probably like, please just call me my real name.
I think the public should know that she, as a gesture to the entire jury, brought 12 dozen eggs, and those were gifts given to her to share with the jury. They weren't bribes. They didn't have secret messages in the eggs. They were just a dozen eggs per juror. And when the judge said, I'm excusing you, she said, can I take my eggs home? That's how we ended up with
Groceries
the
are
eggs.
expensive now. I would get my eggs too.
I have one
Well,
question.
these were damn good, natural farm
I would be
raised.
like, yes,
No
bring me my
country
No
eggs.
eggs.
no steroids. You know, these were good eggs. So why in the world wouldn't you get to take your eggs home?
I have one other question. Then we're going to move to some other things.
I've got one too.
Okay, good. We got two. But you talk about in camera, which is Latin for like in private or in chambers. So what happens there? That's not always sealed. That can be.
Oh, we had the same question.
Okay, so that's not off the record ever. I mean, that's always open to people.
Well, off the record is is not a term of art. Off the record means two things. We do things sometimes that are not in the public view or within the public's hearing.
Okay.
But they are a part of every trial record.
Okay.
And so, for instance, if you're attending or watching a trial, you'll see the judge say, well, I want the lawyers down front. And so all the lawyers toddle on down. And then there's a conference. The judge actually has a button, the white noise button that he can push. It cuts off all the microphones so that the public cannot hear the discussion. Generally, it's about the admissibility of some evidence or some argument between the lawyers, and the judge makes a ruling. But at that point, the public doesn't need to know, doesn't have a right to know, but that technically is a part of the appeal. So when we see off-the-record conversations at the end of the trial, unless the judge takes the action he did in this case to order the record sealed as to those matters, it is on the record insofar as the appellate issues are concerned. It is not available to the public by going down to the court and asking for a copy of everything. It's just under seal. And that's all we're trying to do here.
Gotcha.
Not a big deal. And still scratching my head why the prosecution is opposed to that.
So, I mean, it does give the appearance of, not being forthcoming to open. But so as it stands,
Seton, don't you love that word transparency?
yeah, transparency.
The
That was
attorney-
the word.
you're
That
looking
was
for.
actually the word
Well,
I was
I
looking for,
hate
and
that
it
word
just
because-
escaped my mind.
Yeah, I hate that word because I think it's a bullshit word, but it does aptly describe, I suppose, what comes out of everybody's pie holes about, all this legal processes. But I don't think the Attorney General is interested in transparency in this matter, and that's of concern to me.
Well, as it stands now, because it's been sealed by Judge Newman, and I think the AG's office says he has to be the one to unseal this record. So in the appeals process, is the defense, they cannot reference they can't use that transcript and use that to cite something for an
Oh, yeah,
appeal.
yeah, they can.
Oh, they
Yeah, they
can. Okay, that was.
Yeah. I mean, all of what occurred in backstage and is under seal will indeed be used, and they're in the process of doing that, I presume. The appeals are both in their infancy, but sure, when they brief these things, all of that will be a part of their record and forms a substantial amount of their appeals, because that will be a part of their appeals. No question about it.
Can you explain? It's so confusing because there seems to be multiple levels of appeal. Can you explain to us non-lawyers how this appeal process works and where it goes and what's happening? Because, we have this on July 10th, we have this appellate Richard Alexander Murdoch's motion for certification under Rule 204B. What's happening? What are the next steps?
You bring it up. Well, the appellate process is not all that mysterious. A person convicted of a crime must, within 30 days of the conviction, unless there are motions outstanding or like motions for new trial, which occurred in this case, the appeal technically is filed, and in this case, it's a little convoluted because there's an appeal of the criminal conviction. There's an appeal, essentially, of the denial of the new trial, which those merge into two issues. And then there's the most recent appeal in this case filed, which is an appeal of the criminal convictions that occurred by way of the entry of a plea on the financial crimes.
Oh.
Okay.
In state court. So that's why there's really two appeals. the new trial and original murder convictions merge, I think, into one appeal which is
Okay.
now going to the South Carolina Court of Appeals. And depending on the result there, one side or the other, as the losing party, will have the opportunity to appeal to the state Supreme Court. And the same path will occur with respect to the financial crimes appeal. And of course, that's an appeal in which Alec Murdoch entered a plea of guilty in state court, I think, and in federal court, of course, he received a 40-year sentence, I think, from Judge Gergel. And that matter is also an appeal. And that appeal in the federal system, it runs parallel to the state appeals. And that appeal is to the Fourth Circuit Court of Appeals, and then ultimately to the United States Supreme Court.
Okay, there you go. Spoken like a true professor.
And the Court of Appeals can decide whether they're going to hear it or not, or they just accept briefs.
No, the Court of Appeals is the intermediate court for criminal appeals. So, I mean, after the trial level court, all appeals in criminal cases, with the exception death penalty cases and so forth, those go to the Court of Appeals. So the Court of Appeals isn't, it's not an elective opportunity for them. They have the appeal, and they will, unless the Supreme Court reaches down and takes the case away from them so that the state Supreme Court can hear it immediately and avoid the delay inherent in the Court of Appeals consideration. So the typical time for an appeal to be conducted with two results to the Court of Appeals is probably a year to a year and a half, and then a similar period perhaps to get to the state Supreme Court ruling. So in a death penalty case I was involved in, State v. Quattlebaum, which we may talk about, that case resulted in a conviction of murder with a sentence of death determined by the jury. And because it was a death case, there was no Court of Appeals involved. It went straight to the Supreme Court. So that's one of those exceptions that gives you a direct route to the Supreme Court, leapfrogging over the Court of Appeals.
So let's talk about the case you mentioned. It kind of ties in with both the Murdoch stuff we were talking about and Alec Baldwin's involuntary manslaughter trial in the fatal shooting of the Rust cinematographer. Judge Mary Marlowe Sommer last week dismissed the case. She then ruled shortly after that the prosecution did in fact conceal evidence from Baldwin's legal team. She dismissed the case with prejudice, meaning the charge cannot be brought against the actor again. Her quote is, "The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching prejudice." Pretty hardcore. She said, "There is no way for the court to right this wrong." The defense attorney accused the state of withholding evidence, which they seem to have proved, which ties into this South Carolina case from 2000 that you were involved with out of Lexington, South Carolina, which involved misconduct in a murder trial. As I understand it, you came on board after you were part of the appeals, not on the verdict, right? You weren't part of that original case, were you?
In the Quattlebaum case?
Yeah.
Yeah, I was the trial lawyer. I was. Let's talk about Quattlebaum, and then we'll come back to the Alec Baldwin, because Alec Baldwin is an interesting result in a case of involuntary. Well, I guess he was charged with involuntary manslaughter, as I recall.
Yeah, involuntary.
And that case, interestingly, mirrors, and your listeners can, if they'll Google Vic Morrow of Combat fame, the old television show back in the 60s. Vic Morrow was killed while making a movie, the Twilight Zone movie, killed by a helicopter, being directed to get lower, tighten up the shot by a film director named John Landis of Animal House fame. And the helicopter crashed, took Morrow's head off, and killed two children in his arms, which are part of the were part of the story. Three
my
people
gosh.
killed, and Landis was prosecuted but found not guilty, acquitted of involuntary manslaughter.
Mm.
So that case is one I teach at the law school. So the whole case was something I followed closely, and we'll get back to that. Now, State v. Quattlebaum, a simple death penalty case, if there is such a thing. I was at a cocktail party. Public defender in Lexington came up to me and said, "Would you be willing? I hear you're death penalty qualified." I said, "Yep." And there weren't many of us qualified to do death penalty cases. And she said, "Would you be willing to take one?" And I laughed and I said, "You want me to volunteer for a death penalty case?" And she said, "Well, I've got like 15 of them because I'm in Lexington County, and the solicitor over here, who's known as Dr. Death, he loves death penalty cases. And yeah, would you do that?" And I said, "Sure, but give me one that's really not a slam dunk for the solicitor. I'd like something with a little meat on the bones." Well, it was a interesting case, but about 2 months before the hearing, it got a hell of a lot more interesting when we had delivered to us by the prosecution after, I don't know, a year and a half of silence. We got a VHS tape of a privileged conversation.
Hold on.
Hold on,
Joe.
you
Hold
cut
on,
out
Joe.
for a sec.
Yeah. Are you there, Joe?
Yep.
Okay, you broke up. So start with when I clap. He delivered like what he delivered to you or whatever. Where he
Privileged conversation.
privileged conversation. Yeah. Okay. 3, 2, 1. Go ahead.
So on a bright and sunny Friday, I got a call from the public defender's office. She said, "I've just been delivered a tape by the prosecution." I said, "Okay, what is it?" She said, "It's a video of our client talking to his lawyer, not me, but another lawyer that showed up with him at the police department. And they're talking about the case in private, they think, but there's this recorded conversation, which is an audio video, and it appears to have been made from the ceiling of the room they were in without their knowledge." And I said, "Well, get the lawyer over there and let him listen to it and make sure it's complete." And she said, "This is terrible." I said, "No, this is great. This is misconduct. They stole a conversation. It violates federal law, it violates state law, and it gives us a real issue going into a trial that's supposed to happen in 3 weeks. And we're going to continue the trial and we're going to dig in." So I got on the phone and began to look into the thing, and we got the FBI involved. And it turned into about a half a year delay. Unfortunately, the judge's patience wore out. I have to say the federal government did not do its job in investigating it and pulled punches and leaned in the direction of the solicitor's office. But ultimately, we went forward to trial. The trial resulted in a conviction and the imposition of death. And I can tell you there's nothing more compelling than standing next to your client and having a judge say, "I sentence you to on the 1st of January to die by electric chair." And
Wow.
that's a pretty settling moment for a lawyer and and for your
Of
client.
course. Yeah.
Happily, we made a super duper record in that case. And a year later, I think the Supreme Court reversed the decision and the verdict, gave us a new trial, and Mr. Quattlebaum agreed to plead guilty and serve life, which is what we had offered to do at the beginning of the case, because he was involved in the death of the homeowner. I don't still believe today that he was the murderer, not unlike Alec Murdoch, come to think of it. But it was a fascinating case because of the misconduct that we came to learn involved the deputy solicitor of Lexington County, who was sitting down the hall from this private room where this private privileged conversation between lawyer and client were taking place. And he was down the hall with us, 3 police officers of the Lexington County Sheriff's Department, listening and recording in real time the conversation, and they didn't reveal it. When the lawyer and client came out of the room, they arrested him. And they arrested him based on what he said in that private conversation. And that was what this case involved. And every morning there were so many ethical issues of misconduct by police and by lawyers, prosecutors, that it just meant that we arrived at court every day at 8:30 in the morning, and we argued motions until 10:30, and then we began the case in chief.
Wow.
That trial lasted 2 or 3 weeks. It was a meat grinder. I got death threats. I had my tires cut, and it was a rather stressful thing. If that did, I thought I was immune to heart attack, because if anything was going to give you one, that case would have done it. But I was a hell of a lot younger and probably had dark hair then. But in any event, I'm proud of that case. I'm proud of what I was able to accomplish, which is getting a guy life in prison. But even the defendant believed that maybe that was his just deserts, and he was remorseful about his involvement. But I'm also proud of that decision because it is the leading case in the area of prosecutorial misconduct, because the Supreme Court spanked the prosecutors. I got several police officers indicted by the feds. I got a deputy solicitor prosecutor indicted by the feds, which gave me no joy, because I'd known him a long time. I cannot tell you how disappointed I was in his behavior and his conduct.
Well,
and it got the elected solicitor a public sanction as the captain of the ship in not taking appropriate care and actions. So it's an important opinion for all those reasons.
Have you ever had any other suspicions that maybe people that your conversations with your clients have been listened to?
Oh, absolutely.
Because I've heard that from other lawyers, and I've just wondered if you felt the same way. You suspected that possibly your private conversations with your client have maybe been heard by others.
Well, yes. The simple answer to your question, Seton, is yes. But we live in a day and time when I assume every conversation I'm having on the phone is being listened in on by someone, if not the NSA. Privacies are a diminishing commodity, and we just live with that. But in this milieu, it is not a good thing for prosecutors and police officers to knowingly and intentionally violate the law as they did in the Quattlebaum case. And so that brings you in. I'm happy to talk about that case all afternoon, but it bears on the issues in the Alec Baldwin.
Well, I want to bring it around to that kind of, but I want to talk about real quickly one more thing about the Quattlebaum case is that when you and I talked, one of the important parts of that there were consequences when there was problems or issues or prosecutorial misconduct with the police, and sometimes or many times since they just say, oh yeah, we did that wrong, and there are not consequences, right? Is that one of the things
Yes.
you really want?
Well, in the raising of children, there have to be consequences or behavior does not correct itself. And unfortunately, in the care, feeding, and development of prosecutors, there have to be consequences for doing things wrong, especially when it is intentional misconduct in violation of the law or the ethical canons, the rules of professional conduct. But in South Carolina, we have a very poor history of consequences for prosecutors. I could count on 2 hands and 2 feet the cases that I recall where our state Supreme Courts or the Court of Appeals have found the case has to be reversed because of prosecutorial misconduct, or that the evidence is so overwhelming, even though there was prosecutorial misconduct, we don't grant a new trial. But in each of those situations, the court takes cognizance, recognizes prosecutorial misconduct, and we have very little history, if any, of consequences for prosecutors who commit serious foul deeds in the conduct of cases, their handling of cases.
Who would
That's
be?
why I'm proud of Quattlebaum.
We're not just talking about honest mistakes
Right, yeah.
here.
No, hell no. Everybody's capable of honest mistakes, but
Who's
an
in,
honest mistake that you cover up is
Yeah.
just as bad as a mistake that you make willingly, knowingly, and intentionally to pervert justice.
who should be in charge of leveling those consequences? The Attorney General?
Well, I believe the Attorney General. The Attorney General took the position last year in that case involving a local lawyer, our solicitor, and a local judge who's now retired, who's an old friend of mine, who I think, frankly, got taken advantage of in that matter. But it made national news because a guy who'd been convicted of murder, I think, was released by kind of
Oh, yeah, that was crazy.
a backstage sealed situation. The Attorney General showed up arguing in favor, showed up by motion in the Supreme Court to reverse that deal, to have the court issue an order rescinding the deal, have an arrest warrant issued to pick the guy up because of the lack of transparency and because it was inappropriate. And the Attorney General justified his intervention saying, I'm the boss, I'm the supervisor of all the state's prosecutors. If you ask me, who is responsible for the policing of the conduct and actions of state's prosecutors, the Attorney General has claimed that responsibility to the Supreme Court. And in the appellate opinion from our state Supreme Court, State versus Juror Price, the Supreme Court says the Attorney General of the state of South Carolina has the supervisory responsibility for these purposes of state prosecutors. So, I mean, that's a question the state Supreme Court's answered for us.
And that's Alan Wilson for those of you playing at home. So bouncing back to the Alec Baldwin, I assume you think there should be major consequences for those involved with this travesty of a
Well,
trial.
let's recap. Let's say
Okay.
let's
Okay,
tell them this case was dismissed. But Joe, can you tell us why the case was dismissed against Alec Baldwin?
Sure. The jury had been impaneled. The case was 2 days into the process of the presentation of evidence, and suddenly the motion was made by a prosecutor, and I apologize to her because I'm proud of her in the same way I'm proud of people who come forward. The prosecutor who indicated she came to that case late. She was not, and your listeners may or may not realize that the Alec Baldwin case and charge arises out of a situation of an on-set fatal injury to the cinematographer, the person behind the camera filming. And she was killed when the gun that Alec Baldwin was brandishing as a part of his acting had been loaded with live ammunition, which should never occur, and it is not supposed to occur on sets, movie sets. But his unintentional discharge of the weapon, because certainly he never intended to kill anybody or harm anyone, resulted in the death of the cinematographer. The armorer, the person on set responsible for ammunition and weapons, and primarily responsible for not having ammunition while live ammo, that person was prosecuted and convicted last year. Baldwin was prosecuted and convicted, I think, frankly, as much because he pronounced loudly, probably over the objection of his lawyers, that he never pulled the trigger on that weapon. Now, I've known the same weapon that he was using on that set, and I can tell you, it doesn't go off unless you pull the trigger. It's an old 1893 cowboy gun. But it doesn't happen by accident. But, you know, there was a good case to be made that whether he pulled the trigger or not, he never intended harm, and he certainly had the right to rely on the weapon having dummy ammo in it, caps, if you will. But what happened that is extraordinary in the Baldwin case is this prosecution had occurred under one prosecutor of the armorer, and when the prosecution decided to go forward with the prosecution of Baldwin, because there was a dismissal and then a recharging, a new prosecutor came on board to assist. She is the one who came forward in the 11th hour in the middle of this trial and said, Your Honor, there is a problem with the disclosure of evidence by my side of this case, by the prosecution, that I think is is important, compelling, and I think has prejudiced the defense in a way that we have to bring to your attention. At that point, the old prosecutors who were still on the case, they said, "Oh, well, we made the judgment that we weren't going to produce that because we didn't think it was material." That, in my opinion, is not the rule in any state in this country. And for the logical reasons, the prosecutors shouldn't be making decisions about what is material to a defendant's defense. That's what defense lawyers do.
Right.
And so what's extraordinary about the Baldwin case is that you have prosecutors on the same bench, same team, same jerseys. You've got one prosecutor saying, "My ethics tell me this is wrong," and the other prosecutor saying, "Well, my ethics tell me it's not wrong, and we didn't have to disclose this." So the fact that that argument occurred in public was fascinating to me, and I will say that the interview, there is a compelling interview with this prosecutor who actually operated based upon her ethics and her ethical lodestars to bring this to the court's attention and to provoke what resulted in the dismissal with prejudice of the case against Baldwin. There was an interview with her done, if I can say who, I will.
Yeah, you
but
can.
It's Cuomo on whatever channel that is. It's a fascinating interview, and it was an interview that she gave because her other prosecutors were essentially trying to shift some kind of a blame off on her, and she's saying, "Look, ethically, I had no choice," and that's what prosecutors ought to do. They're supposed to do justice, not just get a conviction.
Well, y'all all took the same oath, right?
We did all take the same oath. Some people were listening on that day, others were not.
I don't know that Alec Murdoch was listening on that day.
Yeah, Alec wasn't listening.
Alec was not listening that day.
Well, if he was listening, he certainly lost his way.
Yes, that's true. Joe, always fantastic to talk with you, and I'm sure we'll be talking again soon.
All right, guys.
Thanks,
Take
Joe.
care.
See you.
Yep,
Bye.
bye-bye.
So off he goes. A couple of things to wrap up this Murdoch episode.
Murdoch-ish
No, it is Murdoch, yeah.
Yeah, so this week it has come out that the AG's office has appointed a solicitor out of Lexington, Rick Hubbard, to help out with the prosecution of Becky Hill. But they're still going to be involved. So some people are questioning, should they be involved in any way? Should there be a special prosecutor? Probably should have asked Joe that question.
Yes. Well, we will.
We will.
But he gave us a lot of information, a lot of really. I was intrigued by all. I'm intrigued by all that law stuff.
I am too, and not to say, I mean, there's some problems with some of the prosecutors, as he's pointed out, but I think the majority of the prosecutors, I mean, Tommy Pope, great guy. There's a lot of prosecutors who are going into it for the right reasons, and taking their oath seriously.
You are correct. Impact of Influence on Facebook. While you're there, you can find the YouTube channel as well. Please rate, subscribe, share, and give us 1,000 stars. I'm part of the Evergreen Podcast Company Network, and we'll talk soon, friend.